Massachusetts, for many, many years, has had a maternity leave statute on the books, which by its terms applied only to females. And it was over the years creating a lot of uncertainty as a matter of law. I think it was in 2008, the MCAD took which is the Mass Commission Against Discrimination, the agency that enforces the discrimination laws, took the position that the statute was violated, constituted gender discrimination because it was not gender neutral on its face. It only applied to women, didn't apply to males who's had a birth or an adoption in their family. Courts weren't agreeing with the MCAD, so the whole issue was a bit up in the air, and it was hard to give advice about it. And fortunately, the General Court, the legislature, stepped forward here in Massachusetts, as in many states, and amended the statute, which went into effect within the last several months, and it's now called the Parental Leave Act, and it provides parental leave for both mothers and fathers for the birth, adoption, or placement of a foster child in the home. So, first true-false question. Parental leave is now available to every employee in Massachusetts. Who thinks that's true? You? Who thinks that's false? The rest of you are uncertain, not brave enough to take a position. That is false. The parental leave law applies only to employees who work at a company of 6 or more employees. And so that's the employer definition size. And to be eligible for parental leave, you have to have either completed a formal probation period not to exceed 3 months or 3 months of employment. So day one you walk into a job, you are not eligible for parental leave. But a male or female who joins, who you hire at 6 months of pregnancy has to work, or 5 or 6 months. They're there for 3 months, and if you're 6 or more employees, they will be entitled to have the benefit of the parental leave after 3 months. Before this, males could have been covered under the FMLA, which is much more stringent requirements. Employers of 50 or more, and to be an eligible employee, you would have had to have been employed for a full year. So this certainly relaxes the requirements, expands the scope, not just gender-wise, but in terms of length of service and the scope of the employers going from 50 to 60, although the mass maternity statute applied to the same group of people. Now, if you are an employer and both the mother and father work for your company, and they're having a baby or adopting a baby, they are each entitled to 8 weeks of leave. True or false? Who thinks that's true? Someone? Anyone think it's false? Okay, more people think it's false. False is correct. Where both parents work for the same employer, mother and father, male and female person are entitled to 8 weeks in the aggregate. So be aware of that. That creates a little bit of a record-keeping problem for the employer in terms of keeping track, because they're allowed to, we'll just use mother and father to be simplistic about it, they're allowed to break up and divide up the 8 weeks between them. So you HR people or your HR department, because you've got benefits issues and medical insurance coverage issues, it does create a bit of a HR nightmare where you've got both husband and mother and father working for you, and you've got to keep track of how they're dividing up the time.
Do the periods have to be consecutive, or can they do a tag team approach?
Well, it's 8 weeks from the birth, so there's nothing that they can do they can alternate weeks, which would be the worst nightmare for HR just in terms of keeping track of benefits and pay issues. Okay, the employer is not required to provide the cost of any benefits, plans, or programs such as health insurance during the parental leave. So as the employer, you're not required to provide the cost of benefits during the parental leave. Who thinks that's true? One person thinks that's true, everyone else thinks it's false. That's true and false. Trick question. So you were all right. The employer is not required to pay its share of benefits for the parental leave unless, bolded, unless the employer provides such benefits to all employees who are on leave of absence. So if your company has a policy of continuing to pay the employer's share of health insurance, for instance, to employees who are out on leave, then you are obligated, it would be a discriminatory act to not provide those same benefits to someone out on parental leave. Okay, so your employee comes to you, whether it's the male or female, and says, I'm going out. First of all, I'm going out on parental leave. I got a due date of such and such a date. You know, it's our first child, or maybe it's their second child. I'd like to take more than 8 weeks of leave, which is a common request. People face that all the time. Someone wants 3 months, 4 months, 6 months. They want to take more than 8 weeks of leave. So under the Massachusetts Parental Leave Act, if the employer agrees to provide more than 8 weeks of parental leave, the employer remains obligated to provide the employee all the benefits under the law, such as job security. So let me just take a step back. The purpose of the law, the main benefit of the law, is that for someone taking parental leave for 8 weeks, or under parental leave under the statute, you have job security. They have to come back to their same or similar position if there's been any economic disruption. So when your employee comes to you and say, I want to take 12 weeks or 6 months, if you agree to that, you then remain obligated to hold their job and provide them job security for the entire length of the agreed upon leave. Who thinks that's true? We got one person think that's true. A few people think that's true. That is false. The employer, sort of true and false again, so I'll give you all the benefit of the doubt on that, because the employer may deny job security and protections only where the employer has clearly provided notice in writing to the employee that they can have the extra leave, but their job may not be protected beyond 8 weeks. So if you have a verbal agreement, you tell the employee, yes, you could take 4 months, you could take 5 months, you could take 6 months, unless you put it in writing that, but we're not protecting, we're not guaranteeing you your job back after 8 weeks, and you just have a handshake deal on that, you will be obligated to provide the protections of the Parental Leave Act, primarily job security, when that employee returns in 4 months, 5 months, or 6 months. So if you want to protect yourself for someone who's going to be out on an extended leave, extended maternity leave, and give yourself the flexibility to say, you could do that, but I can't guarantee that I'm holding your job, you have to clearly articulate that in a written document before the employee goes out on leave. Yeah, question?
Hi. Thank you. What if the person's been there longer than 3 months, they've satisfied the FMLA requirements? Can the FMLA kick in and can they use that as a...
Yes, they would run concurrently.
Okay. If they've satisfied the FMLA requirements?
Yes, if they're FMLA eligible for all that.
Okay, so then we'd be required to protect their job for an additional 4 weeks under the FMLA, is that right?
That is right.
Okay.
Yep, for 12 weeks under the FMLA. And you could, just a heads up, you could have a situation if there's a pre-delivery pregnancy-related disability, then the employee would be entitled to either FMLA or ADA type leave leading up to the birth. If there's a medical pregnancy condition, still then would be entitled to their parental leave following the birth or adoption of the child. So parental leave is not required to be paid leave. Who thinks that's true? That's correct. It is true. Parental leave may be with or without pay at the discretion of the employer.
Gary, I have a question. What if a company has a pay practice of paying the woman 100% of her pay? During that 8 weeks, will they now need to pay?
If the male is taking, so if the employer pays 100% of the mother's or the woman's pay during maternity leave, I think you would be running, I think you have to apply that in a gender neutral basis, because it would be gender discrimination to say you can, but you can't. We'll pay you, we're not going to pay him, based solely on because you're the mother and you're the father. So that's it for parental leave. Just some final points. Employees are required to give 2 weeks notice of the expected date of departure and intention to return, or as soon as practicable if giving 2 weeks is not feasible, particularly in the case of an adoption, where you could be told on a 24-hour notice that your adoption has come through. And the law expands the notice requirements. Employers must keep a posting in a conspicuous place describing the law's requirements and the employer's policies as to parental leave.
Someone asked a question about FMLA. Just to be clear, parental leave, as Gary mentioned, is 6 employees or more. FMLA kicks in when you have 50 employees or more within a 75-mile radius.
And you have to have been employed for the employee a year.
For a year.
So this covers...
And worked at least 1,250 hours in the year, yeah. Also, Gary mentioned that there's no what they call stacking if you have a mother and a father, or mother and a mother, a father and a father for that matter, as employees who were adopting or having the same baby. And what's interesting is that with twins, you do get to stack. You get the 8 weeks for each baby. I don't know about triplets.
Triplets too. It's in the regs. So
going.
this were in the regs under the mass maternity statute. The regulations issued under the mass maternity statute provided 8 weeks for delivery of a single child, 16 weeks for a twin, and 24 weeks for triplets. And it's presumed that those, although the parental leave statute doesn't specifically state, and there aren't any regs, it's presumed that that provision will carry forward.